You didn't even know who you were shooting at, did you?
Yes, I did.
Well, that's not what these people say. I sent
a run towards my car.
A defendant accused of firing 51 rounds in a city is about to watch a negotiated plea deal collapse. Not because the prosecution withdraws it, but because his own answers leave the judge unconvinced that he truly wants to plead guilty. Mr. Bennett faces 2 third-degree felony charges of deadly conduct for allegedly firing toward vehicles. Each case carries between 2 and 10 years in prison and a possible $10,000 fine. The proposed agreement would place him on deferred adjudication in both cases, running concurrently with a $500 fine. That arrangement could allow him to avoid a final felony conviction if he successfully completed supervision. But once the judge examines the allegations, the hearing becomes increasingly tense. The probable cause account says stray bullets struck a liquor store and a passenger vehicle. Bennett claims he was protecting himself, yet admits reloading 3 times while firing 51 rounds. He then questions why a first offense should result in 10 years of probation and gives hesitant answers about pleading guilty. The judge interprets that hesitation as uncertainty and refuses to simply push the agreement through. Will Bennett accept the lengthy supervision and keep the possibility of avoiding a conviction, or take both felony cases before a jury and risk prison?
Looks like he's going to be disposing of both cases, correct?
That's correct.
All right, we have 2 cases called now, 24 CR 303 and 0304. Each of them similarly allege that on or about January 11th, 2024 in Jefferson County, Texas, you committed the third-degree felonies of, this is deadly conduct, discharging a firearm at or in the direction of others, namely a vehicle. All right, you are Mr. Bennett?
Correct.
Okay. These are third-degree felonies, Mr. Bennett, which mean if convicted, you face no less than 2, no more than 10 years confinement in prison in each case, and you can also be fined up to $10,000. You understand the punishment range applicable in each of these cases?
Correct.
Agreements have been reached where you would be placed on deferred or unadjudicated probation on each case. Is that right, everybody?
Yes.
Which will be up, which can be up to 10 years in length, fine $500. These would run concurrently. Do you understand?
Correct.
If I follow this agreement in each case, you have no right of appeal. Do you understand?
Correct.
How do you plead in each of these cases? Guilty or not guilty? How do you plead in each case? Guilty or not guilty? I'm sorry, guilty?
Correct.
Are you pleading guilty in each case voluntarily on your own free will and because you are guilty?
I guess so, yeah.
I'm sorry?
I guess so.
Yes, you are.
Correct.
Yes.
I show you what's marked in each case as States Exhibit 1. Did you sign those documents voluntarily?
Correct.
Did you understand them, discuss them with your attorney? Are the contents all true and correct? Yes?
Yeah, correct.
States Exhibit 1 is tendered into evidence in each of these cases.
No objection.
Without objection, admitted. Among other things, this states you are mentally competent to enter your guilty pleas, which are freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read them. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. You are totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. Is that so?
Correct.
States Exhibit 1 is made a part of the record for all purposes. Pre-sentence reports waived?
Yes, sir.
Stand by, please. All right, I'm looking at this probable cause affidavit.
That's right.
And what happened here?
Somebody shot in my car. Well,
So you quite naturally then fired 51 rounds at other people.
I was actually,
You didn't even know who you were shooting at, did you?
yes, I did.
Well, that's
I
not
see
what
some-
these people say.
I
These
seen them-
people,
I seen them run towards my car, and I discharged my firearm. That's it.
at what? Let's see. You,
I'll be honest with you.
Waji Hamad, let me speak. Waji Hamad, who owns the Last Call Liquor, it was struck by several bullets. He wanted to file charges. Were you shooting at Last Call Liquor for some reason? Huh?
Correct.
Well, that's what got struck by your wild bullet fire.
Man, I got hit in the midst of
Juan Rojas, whose passenger car was struck by several bullets coming from Bennett, he wanted to file charges against you as well. Were you shooting Juan Rojas for some reason?
incorrect.
You shot at it. It hit his passenger vehicle.
I wasn't trying to.
Huh?
My bullets went straight.
Oh, you don't think that can happen when you fire 51 bullets?
Correct. That's what happened.
What do you think? Is that too, are you watching movies? I mean, 51 bullets. What were you firing from? What kind of weapon was it and what was the magazine?
Glock 45. And
How many times did you reload?
3 times.
Sir?
3 times.
You reloaded 3 times. Who in particular were you shooting at that you obviously missed? Who were you shooting at in particular?
My
It's not
target.
supposed to happen in a city. They shouldn't be shooting at you, and you shouldn't be firing 51 rounds at different people who weren't involved.
I was doing what I had to do to protect my child. If you was in that situation, you would have done the same thing.
I'm sorry, sir. You're incorrect. I would be responsible in what I'm shooting at.
Correct.
If you would have killed anybody,
This exchange exposes why the judge considers the alleged conduct so serious. Bennett argues that he fired to protect himself, but self-defense does not create unlimited permission to fire repeatedly without accounting for where every round may travel. According to the affidavit discussed in court, 51 rounds were fired, Bennett reloaded 3 times, and bullets struck both a liquor store and an uninvolved person's vehicle. The judge's point is that intent alone would not erase the potential consequences. If an uninvolved person had been killed, the fact that Bennett may have intended to shoot at someone else would not necessarily protect him from an extremely serious homicide charge. At this stage, however, the transcript does not show a trial resolving whether his self-defense claim is valid. The immediate concern is whether Bennett is knowingly and voluntarily accepting responsibility through the plea agreement. His responses continue to sound defensive, and his suggestion that the judge would have acted the same way only makes the exchange more confrontational. Do you believe firing 51 rounds could ever be justified as self-defense under these circumstances?
anybody, you'd have been charged with murder.
Correct.
In spite of what your intentions may have been.
Correct.
Okay. What was someone shooting at you for? Why were they shooting at you? What provoked this? You have no clue? For no reason? Is that what you're telling me? For no reason, somebody just started shooting at you unprovoked? I know it can happen, but that's not what normally happens in this courtroom.
Can you go ask them?
I'm sorry?
You can go ask them.
Are you being a smart aleck to me?
No, I'm saying.
Who is it?
I don't
Who
know
is
where-
it? Who is it? Who is that person you want me to go ask? What's their name? So why would you say something like that to me? Go ask them. That's just being a smart aleck. Is that your nature? You're reckless. Is that your nature to be a smart aleck?
Just,
That's rude in this courtroom. That's rude. Have you ever been arrested before?
correct.
Is that yes? I'm asking you a question. I'm not making a statement. Or have you been arrested before?
Yeah.
How many times?
One time.
For what?
This.
This, I'm not talking about this event.
No.
For shooting at another time?
No. Correct.
Do you want to go out there and sit in the cell for a little while? What were you arrested for, is my question. Why am I having to pull this out like I'm a dentist pulling your teeth out?
Do you have any other arrests besides this?
That's what I'm asking you. You've never been arrested before other than this,
My
right?
first defense. I'm not understanding why I'm getting 10 years probation.
The plea proceeding has now collapsed at its most critical point. Bennett questions why he should receive 10 years of probation for what he calls his first offense. But the judge hears that objection alongside his earlier hesitation, "I guess I'm guilty," and concludes that he is not firmly committed to the plea. A guilty plea must be knowing, voluntary, and unequivocal. The court cannot accept it merely because an agreement exists or because it may be strategically beneficial. The difference between the two paths is enormous. Under the proposed deferred adjudication agreement, both supervision terms would run concurrently, and successful completion could allow Bennett to avoid a formal adjudication of guilt. At trial, however, a jury could find him guilty and expose him to as much as 10 years in prison on each case. The judge also explains that a jury cannot grant the same deferred adjudication arrangement being offered by the court. Bennett may consider 10 years of supervision excessive, but rejecting it creates a far greater risk. Is the judge protecting his rights by stopping an uncertain plea? Or should Bennett have been given more time to speak privately with his attorney before the deal disappeared?
This is my first defense, so I'm not understanding why I got 10 years probation. That's all I'm saying.
You're not going to get 10 years deferred probation with me. We're setting this for trial. We'll let a jury decide your fate. That's what happens when you're indecisive. These are all situations when you plead guilty, you have to convince me that that's what you want to do. Mr. Dusler, we're setting this for trial. Do you want him to represent you at trial? Are you the public defender on this?
Yes.
You don't even have a job?
Great. I wound up breaking my leg. I broke my fibula in my 2 years.
When?
Like 3 months ago.
Okay, before that, what did you do for work?
Landscape.
How much did you make for landscaping? How long were you a landscaper?
7 months.
Before that, what did you do?
I was working at Sonic.
At Sonic?
Checkers and stuff like that. Just really fast food. I wasn't really working too much. I was trying to get into the plant, but that's a hit or miss.
Well, you won't get in with this over your head. We're going to set this for trial, and we'll let a jury decide. By the way, juries cannot give deferred or unadjudicated probation. If it's probation, you're convicted for the rest of your life for a felony, if they give you probation. And you're looking at up to 10 years on each case, but it would be for a jury. Jury can't give you deferred or unadjudicated probation. You can only get this from the court.
Mr. Bennett, you and I have gone over this at length, and while you feel that 10 years is a long time to be on probation, you understand that the court was going to cut you a break by giving you deferred adjudication.
Also, I can shorten it by a third, but for people who do,
Exactly.
which I do every day.
Since you've never been on
But
probation,
that's not going to be applicable in this case.
since you've never been on probation before, the district attorney and the court were going to cut you a break and offer you deferred adjudication. You may not like the length of the term of probation, but that's generally what the judge.
It's in the place to sell it. I mean, it should have been done a long time ago
And
before we come up here.
It was.
And that's, so do you want to keep him for trial or not? Yes or no?
You want to replace me and let him get a different lawyer, you can get it to court with you.
It's your option. He's a good lawyer. There is no answer. You will, under the rules, you will be representing, and we'll set these for trial. Get a resetting from that lady, and we're going to try this one.
Judge, I think he's responding now.
I really just got to think about it. That's a lot. really
Get the resetting. Mr. Dusler is your trial lawyer. He's a fine trial lawyer. Get a resetting. We're going to trial. Heather Boudreau is next.
This hearing ended without a conviction, a sentence, or acceptance of the proposed plea agreement. Mr. Bennett had been offered concurrent deferred adjudication supervision in 2 third-degree felony deadly conduct cases, along with a $500 fine. Each charge carries a potential punishment of 2 to 10 years in prison and a fine of up to $10,000. However, Bennett repeatedly appeared uncertain about pleading guilty and questioned the length of the proposed supervision. After reviewing allegations that he fired 51 rounds, reloaded 3 times, and struck uninvolved property and a vehicle, the judge concluded that Bennett had not convincingly demonstrated that he wanted to accept the agreement. The court therefore stopped the plea and ordered both cases set for trial. Bennett's appointed attorney remained as trial counsel after Bennett failed to clearly request a replacement, although the judge advised him that seeking another lawyer was an available option. The crucial takeaway is that deferred adjudication was a benefit only the court could provide in this situation. A jury could convict or acquit him, but could not grant that same resolution. Did Bennett make a costly mistake by hesitating, or was taking the case to trial the right choice? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.